Hello, and welcome to the next seminar in the Dean's Court Chambers seminar series. I'm Liam Kelly and I'm a member of the family team at Dean's Court Chambers. I'm going to be talking to you today about maintenance pending suit. Unlike financial provision at the conclusion of an application for financial remedies, an application for maintenance pending suit is often brought at an early stage in proceedings and is often decided without full disclosure. The aim being to bridge the gap in finances until such time the proceedings are concluded. As a result, the court is often asked to make a broad assessment of the financial landscape to determine what, if any, order should be made. In the words of Coleridge J., it is designed to deal with short-term cash flow problems which arise during proceedings for divorce. Its calculation is sometimes somewhat rough and ready, as financial information is frequently in short supply at the early stage of proceedings. Published judgments with respect to maintenance pending suit, or MPS as I'll refer to it throughout this seminar, are rare. However, in January of this year, 2 decisions, including a decision of the Court of Appeal, were handed down considering the legal landscape with regards to an application for MPS. The first is the matter of Rattan v. Couillard. That's a decision of the Court of Appeal, the judgment being given by Lord Justice Moylan. The second is the matter of R.V.R., a decision of Mr. Nicholas Cusworth, Queen's Counsel, sitting as a Deputy High Court Judge of the Family Division. The focus of this seminar shall consider the decision in the matter of Rattan. The statutory basis for bringing a claim for MPS is Section 22(1) of the Matrimonial Causes Act 1973, which states that on a petition for divorce, nullity of marriage or judicial separation, the court may make an order for maintenance pending suit, that is to say, an order requiring either party to the marriage to make to the other such periodical payments for his or her maintenance and for such term, being of term beginning not earlier than the date of the presentation of the petition and ending with the date of the determination of the suit, as the court thinks reasonable. It is important to note that an application should not be brought under Section 22(1) if the order is sought for the payment of legal fees, which would be a separate application brought under an alternative provision. As Moylan L.J. set out in the case of Rattan, this is a very broad statutory power, which extends to the court making such order as the judge thinks reasonable. As a result of the broad discretion afforded to the court, the manner in which it should be exercised is contained within guidance given by the courts. But what does reasonable mean? Nicholas Mostyn, Queen's Counsel, as he then was sitting as a Deputy High Court Judge of the Family Division, said that reasonable equates to fairness, consistent with the overarching objective in financial remedy cases, which is that the outcome should be fair. Of course, as set out by Lord Nichols in White v. White, then fairness, like beauty, lies in the eye of the beholder. However, as Lord Nichols goes on to say about financial remedies more broadly at paragraph 23 in White, implicit in the object must be to achieve fair outcome. The purpose of these powers is to enable the court to make fair financial arrangements on or after divorce in the absence of agreement between the former spouses. The powers must always be exercised with this objective in view, giving first consideration to the welfare of the children. What then is maintenance pending suit for? As referred to in Rattan, by reference to the Red Book, the purpose of an order is to meet the immediate needs of the applicant. Of note, this was the principal issue under consideration by the Court of Appeal. But what is an immediate need? Moylan L.J. expressed that the key factors are likely to be the parties' respective needs and resources and the marital standard of living. However, beyond those considerations, the court was clear that the approach taken should be tailored to the individual facts of any particular case. However, whilst there is unlikely to be sufficient resource to enable the maintenance of the standard of living for both spouses and children, a separation in principle does not provide a reason of itself to reduce, or indeed increase, the standard of living. He went on to say that the word immediate in this context does no more than reflect the fact that the court is concerned with an order for maintenance pending the final resolution. Immediate, therefore, should be taken to mean nothing more than between now and the time the matter is concluded. It does not, for example, mean urgent, and that should be borne in mind when considering an application for MPS. In this particular case, the applicant had sought an additional one-off payment of £3,250 to cover essential repairs to the house, such as heating, hot water, and repairs to the stove. Importantly, he noted that the fact that some items of expenditure are not incurred every month does not mean they should be excluded for the purposes of determining what is reasonable. Further, the applicant had sought within her claim for MPS sums towards school fees. Moylan LJ held that school fees can be included within income needs and can form part of an order for MPS. There is no reason why they cannot form part of the applicant's immediate income. What then are the principles, or the guidance as Moylan LJ referred to it as, to be applied when the court is dealing with an application for maintenance pending suit? In TL v ML, Nicholas Mostyn, Queen's Counsel, again as he then was, summarised the principles derived from the case law in the following ways. The sole criterion to be applied is reasonableness. Reasonableness is akin to fairness. An important factor in determining fairness is the marital standard of living, albeit it is not simply to replicate the same. In each MPS application, there should be a budget. This is something I will return to shortly, and that budget excludes capital and long-term expenditure, which is more aptly dealt with at the final hearing. That budget should be critically examined to exclude forensic exaggeration. Where the Form E is obviously deficient, the court should not hesitate to make robust assumptions about the respondent's ability to pay. The court should favour the payee. Where the applicant has historically been supported by an outsider, and the position of that continued support is unclear, the court is justified in assuming that the outsider will continue to support, at least until such time there is a final hearing. In giving his judgment, Moylan LJ considered a further principle should be considered as he set out in his earlier judgment in G v G, which was taken from his judgment in BD v FD, maintenance pending suit, as appears there on screen. In his view, given the expense incurred for an interim hearing, one should only be pursued when on a broad assessment the court's intervention is manifestly required. In his view, those remarks which at that time applied to child maintenance equally apply to interim maintenance under the Matrimonial Causes Act 1973. Turning back then to the issue of budgets, the principle of the need to critically examine the budget derived from the case of FVF. Thorpe J, as he then was, decided that there should be a critical examination of the budget. However, in that case, unlike in Rattan, the court was concerned with a significant sum of assets totalling several £1 million. Moylan LJ stated that in Rattan, it was the type of budget which will be very familiar to judges determining financial claims, and which they are well placed to decide, on a broad assessment, whether they are not reasonable for the purposes of to determine an application for maintenance pending suit. He determined that the court need not undertake any greater critical analysis of needs in this case than would be required in any other aspect of the case, and such analysis undertaken by the court must only be sufficient to be satisfied the award is reasonable. Whilst Moylan LJ did not close the door on the need to look critically in some cases as to the specific budget required, he considered that immediate needs will often be immediately apparent. To conclude then, what are the takeaway points when considering maintenance pending suit? Firstly, when considering whether to make an order for MPS, reasonableness is the sole criterion. Secondly, the marital standard of living is important, but it is not determinative. Thirdly, in big money cases, a budget is more likely to need critical scrutinization, as in cases with modest assets, immediate needs are more likely to be immediately apparent. Next, the fact a payment is not a regular monthly payment does not mean they should be excluded when considering the test of reasonableness. And finally, school fees may form part of a party's immediate needs.